Hi, my name is Mia or Kaijun, and in this video presentation, I will be explaining the relevant topic pertaining to registered land regimes. I will also be answering Alan's situation and also for Tina and Chris. So I will now be giving a brief introduction of the Land Registration Act of 2002, which is highly relevant in regards to registering land in the United Kingdom. Thus, naturally, will apply to Alan, Tina, and David. So, firstly, um, the Land Registration Act of 2002 replaced its predecessor, which was the Land Registration Act of 1925. So it was mainly replaced due to its lack of certainty and clarity to those who wanted to acquire and inquire interest in the land in question. So it was mainly to meet the large demand as it grew along the years. So the Land Registration Act of 2002 was created to act as a major improvement to its predecessor to keep up with the information and technology trend. So I will now explain the brief structures of the brief structures that will be applied when you um, register your land. So the first, if your title has already been registered, then you will fall. Then your according to section 58, your entry on the register will be conclusive and it will be repeated into the registry. So, if your title is not yet registered, then that means it will be your first registration. So you'll fall under section 27. That means all change in ownership of the title and creation of legal interest affecting the title must be notified to the land registry in 2 months. Legal ownership won't pass to the purchaser unless they apply for the registration and is registered as the new proprietor. Thus, it will be Alan. So once your land is registered, a title will be given. There are generally four titles. First being the absolute title. So this means that the registrar is with the opinion that the person's title to the estate is such willing that a buyer could properly be advised by a competent professional advisor to accept. The second is the good leasehold, and but it's not a perfect title, and there's a defect. It can be resolved, but it is unprotected. So that means there could be other parties that could have a stake in your land, so and you won't be able to enjoy the full extent of your rights of the land. The third being your qualified title. But it's quite rare. So it is a defect that can't be ignored, and it is not considered good and marketable. So if a registrar thinks that the person's title to the estate is established and only for the limited period or subject to certain reservations, and it is so big that it can't be ignored or disregarded. The fourth being possessory title. This is where titles cannot be proven. So thus it is not perfect at all. There is no full information disclosed, and there's zero documentary evidence as to their title to the land. And it and the third is the types of interest. So your interest can be either registered or unregistered. So for registrable interest, it is either like freehold or proper leases with a stipulated time frame. Then there is a registered charges, which is like legal mortgages, um, interest subject to an entry to the register, or third-party interest. This is where their third-party interests are protected by the registration, such as like notices and a unilateral notice. And the fourth being interests that override. These are interests that are not registered on the register, but they still bind third-party purchasers and the main purchaser. So under the Land Registration Act 2002, it is now called interests that override under Schedule 3, which will be explained further down. So I will now explain how the Land Registration Act 2002 has provided sufficient protection to a proprietor like Alan. So um, the first is that because the Land Registration Act of 2002 is built upon principles such as the mirror principle, it is beneficial because it relies on the registration of all rights. Because based on the mirror principle, the register makes sure that their registry is an accurate and conclusive reflection of ownership title and relevant interest affecting the land in question. So the basis and provisions of the LRA is built upon e-conveyancing, and in due course, creation and transfer of most property rights or registered land is ineffective unless it's done through electronic registration. Because of this, the registration gap will disappear, and it will enable quicker processing, and it will be more accurate as well, thus being a truer mirror because it conclusively reflects it. It also reduces, and because of it being electronic, it also reduces the workload of officials, where they could focus on like other important matters, and it's also quicker for administration basically. And also, The act will be beneficial for Allen, such as in terms of accessibility. There'll be lesser waiting time and overall lesser complexity to not only just Allen, but to anyone else who wants to register their land. The second is also known as the insurance principle. This is where the accuracy of the register is guaranteed, and if the register is found to be inaccurate, it will be altered or rectified surely. The state will guarantee the efficacy of the system by providing statutory compensation, or known as indemnity, to persons suffering from losses by treason of the operation system, such as a faulty, when there's a fault in the system, basically. So according to Section 55, operating to Schedule 4 of the Land Registration Act 2002, it establishes circumstances by power to give indemnity compensation under Schedule 8, complemented by under Schedule 8 when a person suffers loss by reason of a mistake in the register, whether the register is corrected or not. So as long as there's a mistake, you will get compensation. So this is definitely an improvement from the Land Registration Act 1925, allowing alterations by the court and the registrar, and by thus ensuring integrity of the register won't be compromised by allowing widespread alterations to be made. So in the case of Goldhart Properties and McLeod, if in the register is caused entirely by the wrongful removal of a lease based on false information, it's just an example, then indemnity will be provided. Wider powers are also given to rectify. Wider powers to rectify will naturally lead to a wider scope for indemnity, and there's also added considerations based on human rights principles, where in dire situations you have to make sure indemnity is provided, and if not, it's not fair. And the third is restrictions. Restrictions used in the Land Registration Act of 1925, but it was given greater importance and concentration in the now 2002 Act. So a restriction places limitations on a registered proprietor's powers over the land. It controls the registered proprietor's ability to sell the land or deal with it. So according to Section 23, for example, a third party's right is protected due to the restriction that prevents the disposition of the land. So a restriction sets aside those rights. Limitations vary, restrictions or limitations vary from specific events to periods to placing limited power of land on the others. So if there is another person's consent that needs to be dealt with for a registered title, it will be set up and registered in the proprietorship register. So the HM Land Registry encourages uses of standard form restrictions, which makes application processes smoother, cheaper than if a non-standard restriction is applied for, thus also ensuring greater protection all around. However, there are issues that could override Allen's titles. So the Land Registration Act does not fully protect it, which is because of the overriding of titles. The first being rights of occupiers. This is under Schedule 1 and 3, which again will be explained later down. So you can override a title if 1, there is actual interest, 2, there is actual occupation, and 3, no inquiry by the other. There's also short leases, where they are leases granted for a maximum of 7 years or less, and easement profits, which are positive or negative rights of using the land in question. So rights of occupiers, short leases, and easement profits are a few categories that allows overriding. So I will now talk about extra considerations regarding the Land Registration Act, because although the Land Registration Act is a significant improvement and step forward, there is a major flaw. So the first being a term called the crack in the mirror. So what does this mean is that it doesn't actually fulfill its true purpose of ensuring all details are present and known by the buyer and on the register. Because of the act highly emphasizing the mirror principle, this is actually one major flaw, purely because on overriding interests. This is because, as previously explained, overriding interests are not registered in the registry. Because they are not registered on the registry, the need for inspection actually ventures away from the electronic register, which means that you actually have to go out of your way, out of the register, to assess the right and to assess whether it's valid or not. So because of this, it actually defeats a major purpose of the act. Another, it being electronic mishaps. So accidents happen. So accessing information can be difficult if electronic or even system troubles occur. So because of this, it would be difficult to access necessary data at given times. It would be productive actually to maintain certain manual records as precaution. However, this issue rarely occurs now due to technological advancements that prevent the frequency of electronic disruptions. So it can be avoided, but it is still a flaw. Right now, I will then explain the Schedule 1 and 3 in detail regarding overriding interests because it is relevant to Tina and David. So, in order to override, the original purchase of the land, you need to satisfy three elements. The first being interest. You must have sufficient interest in the land. So, according to National Provincial Bank in Ainsworth, I quote, rights referred must be proprietary rights and not merely personal rights. The second is actual occupation. So you must have actually lived there at the time of questioning. So you must have actually been staying there up to the point where it is assessed and the purchaser found that you are still staying there. So I quote by Hodgson and Marks, actual occupation means mere physical presence. And thirdly, no inquiry by the other. That means that occupation should be obvious by inspection at the time of the disposition, or the purchaser actually knew that the client had interest in the first place. So I will now apply the law from the previously explained Schedule 1 and 3 to Tina and David, as it is highly relevant in their case and to establish their relevant positions. So I'll first do Tina. So once again, in order for Tina's interest to override Alan, you need to establish the three elements. The first being interest. So she has sufficient interest in the land and sufficient proprietary rights. And for actual occupation, she is in actual occupation at the time of the land, and at the time the cottage was sold to Alan and thus has mere physical presence. So at the time she was actually living in the property, and when Alan bought the property, she was already there. For no inquiry by the other, it is reasonable of Alan by inspection to identify that Tina has already been living in the cottage, so it was obvious. So by looking at it, Tina is more successful. But for David, this is where it gets interesting, especially for the second element of actual occupation. So for interest, he already has sufficient interest in the land and sufficient proprietary rights because of his pre-agreements with his brother Charles. But for actual occupation, however, he wasn't in actual occupation at the time of the sale, and to Alan, and his right of occupation didn't actually exist at the time when Alan purchased the cottage. So because although he has his pre-agreement with the brother, yes, he already agreed with the brother way before Alan bought the property, but he wasn't actually living there when Alan bought the cottage. So this principle was found in Abbey and National Building Society in Cannes. And for the third element, no inquiry by the other, there was no way Alan could know at the time of inspection, and Alan did not know David had interest until he told Alan of his interest, that, oh, I am interested. So this means that element 2 and 3, David did not satisfy element 2 and 3 to override Alan's interest. To override Alan. So to conclude, I would say that Tina will be able to sustain and override Alan's interest. David, on the other hand, will not be successful because he cannot satisfy the second and third element of Schedule 1 and 3 Land Registration Act of 2002. In the case of Alan, however, I would say that the Land Registration Act actually does provide him with sufficient protection as a registered proprietor in the grand scheme of things. Because number one, the mirror principle, the restrictions that we talked about, and the indemnities, the insurance principle. But because of the cracks in the mirror, purely because of overriding interest, he isn't fully protected by the act as he clearly experienced from Tina and David. And also, because of the electronic mishaps, delays and troubles that could be avoided will naturally occur. But I would say that it will be inconsequential in the future because of technological advancements. So thank you all for listening.